Hello, it's Stephen Stein with the law firm Greenwood Lesker, and along with the partner organizations reflected on this page, this is the fourth module of our small claims clinic presentation, and it's about the small claims hearing and the aftermath. So let's go ahead with that. So let's talk about the small claims hearing itself. A very important difference between this hearing and a hearing in general civil court is that no attorneys are involved in this unless they're themselves parties. You are representing and speaking for yourself. So no attorneys allowed. So that's one unique aspect of this. There are a few limited exceptions where other people can speak on your behalf. That's if, for example, you're a minor bringing a claim, or if you're a landlord bringing a claim or defending a claim, the property agent can potentially be the person speaking at the hearing on behalf of the landlord. And then if it's a business entity, typically you would need to have a regular employee, officer, director, or partner of that business entity speaking, so long as they're not hired just for the purpose of appearing and speaking at this hearing. And there are certain forms that you need to fill out if someone else is speaking on your behalf. So preparation is a very important part of having a successful hearing. So it's important that you gather your facts, documents, physical evidence, and witnesses. And we'll get into all of those points. So let's start with the facts. You should be able to present all the important facts to the court in an organized and understandable manner. Remember that while you may have been living with the situation that brings you to court for a long time, the court knows very little about your case and has a limited amount of time to hear your matter. Consider presenting the facts in chronological order. Perhaps a chart or timeline would be helpful, and the judge may receive a copy to follow along with you. Prepare notes of what you want to say so that you do not have to leave out it, so that you don't leave out anything important because you will likely be nervous. Some judges find it helpful to have a brief 1 or 2 page summary of your position or even bullet points. If you prepare a summary of your position, you should file the summary in advance of the hearing, at least 5 court days before, and serve a copy of the summary on the other party by mail. If possible, go observe one morning in small claims court. It will help you understand the process and calm your nerves. And here's a little tip. If you're the plaintiff, make sure to focus on liability before damages. So what does that mean? In other words, make your case for why the defendant is at fault before making your case for how much money you're owed, because you're not going to get the money you believe you're owed if you don't first establish that the other side is at fault. So for example, if you're suing based on a car accident, first present the facts and evidence showing that the accident was caused by the defendant. So for example, a police report would help show that, and then present the facts and evidence showing the cost to repair the car and receive treatment for any personal injury. For example, the appraisal might help with that. If you're the defendant, what defenses do you have? On the facts, do you believe that you are actually at fault or don't owe the plaintiff money? If there was a car accident claim, your defense might be that you weren't driving the car, or that you didn't own the car, or that you did nothing wrong. On the law, even if the facts plaintiff claims are actually true, is there some legal reason why plaintiff can't get an award against you? There are many legal defenses, and it may be a good idea to consult an attorney if you think one is applicable to your claim, to your case. A few to consider include: how old is the plaintiff's claim? Recall we talked about the fact that each claim must be brought within a certain time period. If the plaintiff's claim was brought too late, for example, then that would be a defense. If the plaintiff needed to file it within 2 years, and the plaintiff filed it within 3 years, that might be a legal defense. If it's a contract claim and it was a contract that needed to be in writing, like one for the sale of property, if the contract wasn't in writing, that might also be a defense. And so those are just examples. And so that covers sort of facts. Let's go on to documents. So a document includes anything tangible that has information recorded in it, including any bills, invoices, emails, printouts of information stored on a computer, recordings of a voicemail, photographs of the injury, the car or the scene, letters, receipts, etc. So gather all the important documents, put them in order of importance to the case, and if you're not sure what order to use, put them in chronological order. Consider attaching the most important documents to the plaintiff's claim form when you file the plaintiff's claim form with the court. Make 3 copies of each to bring with you to court. One for the court, one for the other party, and an extra for yourself. Make sure to keep your original documents separately and bring them to the court in case the judge wants to see them. It's possible the hearing will be online. If so, there will be an opportunity to electronically exchange with the other side and provide to the court documentary evidence. Consider marking a document to highlight or tab certain information that is of particular importance, such as the specific contact provision that relates to your case. So if there's an important contract provision, you want to highlight that for the court. Consider putting your documents in a binder with numbered tabs and an index so that they are organized and easy to find during the hearing. Do not forget any physical evidence you may have, a torn dress or damaged bag, a broken part, or anything else that might be important for the judge to see in deciding your case. Let's go next on to talk about witnesses. So that's another part of preparing for the hearing. You must have any important witnesses appear at the hearing, if at all possible. Ideally, they should be witnesses who want to come voluntarily. If the witness will not agree to come voluntarily, so for example, a police officer witnessed a car accident and you want them to testify, but they're not willing to come on their own volition, you can serve the witness with a court order to appear. And the legal term for this is a subpoena. And there's a form, SC 107, that's the subpoena form. As a side note, you can also use the subpoena to get records from a public agency. So unlike service of process, serving the defendant with a complaint, a party can serve the subpoena his or herself. You don't have to get a third party to serve it. A witness may request a witness fee to appear, and that would be $35 plus 20 cents per mile each way from their home or workplace to the courthouse. And if it's not paid, the witness does not have to appear. It's also possible a witness could appear electronically, and you should check with the court about this. If it's not possible to get a witness to the court, obtain a sworn statement from each unavailable witness to bring to court. This is known as a declaration. In a declaration, a person swears under penalty of perjury, just as if they were in court, that certain facts are known to them personally and are true. If you don't speak English or understand it fluently, you may bring a person with you to interpret for you. The court will have a list of available interpreters who will assist you for free or for a minimal charge, or you can bring someone you know to help you. However, the judge is not required to allow someone who is not certified to perform translations act as your interpreter. If the person is not acceptable to the judge may postpone your hearing to a later date to allow you to find an appropriate interpreter. So another important thing is where you are going and when to be there. That's sort of a basic but important thing because, you don't want to miss your court appearance, by the way, you want to make sure you're there and you're there timely. And so on that point, if the hearing is in person, make sure you know exactly where you need to go for the hearing, what address and which room. Get there early to avoid added anxiety by being late. You have to go through security, so allow extra time for that process. Now, finally, we've reached the hearing itself. Hearings can be virtual or in person. And there's a check-in process either electronically or online. But when you arrive in person or online at the hearing, check in with the clerk of the court, advise the clerk of your name and case number. If you have documents for the court, ask if the clerk would like them now, as opposed to waiting until your case is called. If you have some urgent reason you need to leave, such as childcare or a sick relative, advise the clerk and ask if your case can be heard early in the calendar. Be aware that such requests cannot always be accommodated. So who will hear the case? You're going to have your case heard by a judge or commissioner or a judge pro tem, which is an attorney with at least 10 years experience in special training. If there is a judge pro tem sitting on the bench on the day of your hearing, you will need to stipulate to allow the judge pro tem to hear your case. If either party refuses to stipulate, you'll need to come back on another day for your hearing. What about presenting your case? Remember that the judge has a very limited time in a lot of cases. The judge might not know much about your case, and they'll need to figure it out fast. So focus on the essential facts and evidence. While the length of the hearing can vary by judge, it's possible the hearing will only last a few minutes. Be calm and logical in your presentation of the facts, documents, and physical evidence. Do not get emotional or excited. If the judge starts talking, you should immediately stop talking and listen to any question the judge asks. Answer the question directly, yes or no if possible, then add any short explanation you think necessary, and talk only to the judge, not the opposing party. All right, so that's sort of the hearing and what that involves. And we've now reached the judgment and appeal. So with respect to the judgment and appeal, you will receive the judge's decision at some point, right? So the judge may rule on the day of the hearing. That's called ruling from the bench. But it's more likely that the judge will tell you that he or she is taking the case under submission, meaning the judge will send a written decision by mail, generally within 10 to 12 days of the hearing. And note that the timing may vary by the courthouse and judge. It's rare for an explanation to be provided for the decision. This is something that can be frustrating and disappointing to litigants. The judgment comes on a form called the Notice of Entry of Judgment Form, SC 130, which starts the clock ticking for any further action from the date it is mailed. So let's talk about what happens if the defendant wins. If both parties come to the hearing and the judge finds in favor of the defendant, the case is over. The losing plaintiff does not have the right to appeal. This is a rule unique to small claims court. Plaintiff may file a request to cancel judgment on the grounds that the judge applied incorrect law, but since this is considered by the same judge, it's unlikely to succeed. And that must be filed within 30 days of the notice of entry of judgment. Okay, so that's what happens if the defendant wins. But what if the plaintiff wins? If both parties come to the hearing and the defendant loses on the plaintiff's claim, the defendant may appeal. To appeal, the defendant files a notice of appeal, Form SC 140, and that cost is $75, unless it's waived, within 30 days after the date the clerk mails the notice of entry of judgment. And then there will be a new hearing on all claims. The hearing will be before a superior court judge. The hearing will be informal, just like small claims. Attorneys can represent parties. The judge fully retries all claims of original parties to the small claims action and for the original amount. There's the possible reimbursement of attorney's fees, expenses, and loss of earnings related to appeal. A party who appeals for the purpose of delay or harassment can be penalized, and this decision is final and not appealable. The defendant may also file a request to cancel judgment on the grounds that the judge applied incorrect law, but just as we discussed previously, it's going to be hard to get the court to agree to that because the court's going to have to reverse itself, basically. And to be clear, filing this form does not extend the time to file an appeal. So let's just pause there for a second. This is a unique component of small claims court. If the defendant wins, the losing party, the plaintiff, the losing party doesn't have the right to appeal. Whereas if the plaintiff wins, the defendant has the right to appeal. And that's different than how it normally goes in regular litigation. So let's say the plaintiff wins, the defendant owes plaintiff money. If the defendant wants to pay the judgment in installments, the defendant can file a request to pay judgment in installments. So what if there's a judgment against a party that doesn't show up? Let's go to that next. When a defendant doesn't show up, a plaintiff still has to prove her case and that a proper proof of service was filed. If a plaintiff or defendant doesn't show up to the hearing and a judgment is entered against him or her, he must file a notice of motion to vacate judgment. That's Form SC 135, which is a request to have a hearing to cancel the decision. If the plaintiff who doesn't show up or defendant who was served and doesn't show, the party that didn't show must file a motion to vacate within 30 days from the date the court mailed the notice of entry of judgment. A defendant who is not properly served must file the motion to vacate within 180 days from when they learned of the judgment. The motion granted, it's granted if there is good cause. So for example, if you miscalendared the case, your child was sick, there was a death in the family, that might be a reason why the court might grant that motion and allow you to reschedule the hearing and argue things. So that's one thing that could happen. But if the motion to vacate is denied, then what happens is that the defendant has 10 days to appeal to the Superior Court by filing a notice of appeal form. So that's what you would do in that circumstance. And so the point is that important to remember from the appealing a decision standpoint is that if the defendant moves to correct or set aside the judgment, that's fine, but that doesn't extend the defendant's time to appeal. So that's something important to keep in mind. Another important thing to keep in mind is if you don't show up at the hearing and judgment is entered against you, you cannot immediately file a notice of appeal. Instead, you have to file the notice of motion to vacate. And if you win that motion, the case goes back to small claims court to be heard on the merits. If you lose it, the judgment stands. So that's talking about a motion to vacate. Now, what about voiding an old judgment? Let's say you don't learn about a judgment for various reasons until much later, let's say over 180 days after it was entered. If that's the case, then instead of filing a motion to vacate, you should file a motion to void the judgment. And ask the judge to set that judgment aside because the complaint was not properly served. And the form that really captures that is the request for court order and answer form, SC 105. And so that's what you want to do. But if it's really well past the hearing date, if the judgment is more than 2 years old, the judge will probably not set it aside. In that case, you should consider asking for a payment plan, which will at least at a minimum protect your driver's license and your paycheck if there's garnishment. There's also something called a conditional judgment, and that might come up. A conditional judgment is a decision that conditions the award of damages on non-compliance with the court's order. The judge maintains control over the matter until the follow-up hearing to see if losing party has paid the money or has done the thing the judge has ordered. And if the conditions are met, the judge will dismiss the case with prejudice, meaning it can't be refiled. And this is intended to avoid damages to a person's credit record from entry of judgment. So, example, a court might award a judgment in favor of neighbor A and against neighbor B for the cost of removing branches that unreasonably overhang on neighbor B's property and cause the risk of personal injury. But the judgment might only become effective if the defendant doesn't remove those branches. Moving on to collections and payment of judgment. So you are the judgment creditor if you won the claim. The losing party is the judgment debtor. The judgment becomes final 30 days after you receive the notice of entry of judgment form. If the judgment debtor has not filed a notice of appeal or notice of motion to vacate judgment. If you collect the judgment, you must file either the acknowledgement of satisfaction of judgment section of the notice of entry of judgment form or the longer acknowledgement of satisfaction of judgment form. And one of the key things to remember here is just that it's not always easy to collect on a judgment, that you can go through this whole process and get a judgment. And so defendant owes you money, but then maybe the defendant doesn't have money to pay you, or maybe the defendant tries to make it difficult for you to collect on the judgment. So that's just another wrinkle to any type of litigation, but to small claims actions, that is all the more reason to consider trying to resolve things early on or at some point during the dispute. And, as we said, if you're the losing party, you become the judgment debtor. If you don't pay within 30 days, you have to disclose your assets to the winner, which may also require you to appear in court to answer questions or produce documents about your assets that may be available to pay the judgment. And that form is the SC 134 form. So look, more information about all of this is available online, but this now concludes our presentations relating to the small claims process, and thank you for watching them.